Okay, good afternoon. This is the Board of Standards and Appeals Public Review Session for October 5th, 2020, 2 p.m. session. There is no public testimony taken during the review session. Please do not call in. The first item to be discussed is SOC calendar continued hearing items. Item number 17, 2308BZ, 80-14 Chevy Chase Street, Queens.
Okay. Sorry, I have a lot of notes on this. The saga continues. Commissioners should note that 2 submissions were made on this application on September 17th and 23rd. And so the latest plan set is on September 23rd. I start off with, even though it's not the most surprising part of the news, what is it about the word in-ground planting beds that this applicant doesn't understand? We don't mean potted plants. We mean break up the concrete, dig a hole, line it properly, pour curbs all the way around, add soil, and plant the trees. Not negotiable, no excuses accepted. Where a cellar sits below a potential planting bed, which is not the case at the side lot lines, build the full bed above ground with adequate soil depth and bed width length to support the planting. Line the planter the way it is done in every one of the POPs parks in the city, the public open spaces, nearly all of which are built above cellars. This is not an excuse to have potted plants. The applicant's counsel knows this board's view of potted plants, and the applicant should have listened to their counsel's advice not to show them. So I'm actually very surprised to see that even submitted at all on the materials. There are statements about measurements having been taken to verify the roof and parapet heights above curb level. Applicant has to provide the signed and sealed surveyor's measurements. This holds true also for the location of the building relative to the property line, where a bit of shocking news reveals that the new building at the cellar may have been built 5 to 6 feet onto city property. Yay, something new, right? We do not move forward with this application until the applicant establishes with certainty that this was a pre-existing legal condition, which frankly is a little hard to believe was the case. This is a low brick wall and cellar built all the way around the property. In the last couple of days, our deputy general counsel, actually it was last night, our deputy general counsel was able to find historical satellite imagery. I think you do it on, and correct me, Chase, if I'm wrong, you do it on Google Earth with timeline, which I wasn't able to access, but he was. That shows the existing building was demolished by 2009. So I don't know what kind of vesting argument one would make for encroachment onto city property like is done. As applicant knows, this board has no authority to waive encroachments on city property. And if it's not a pre-existing as of whatever date is required by either DOT or city planning or however that's analyzed, then the applicant will have to remove the encroachments or go to city planning to get a revocable consent, in which case we can't decide on this at all until that's clarified. The sections provided also don't show the cellar extending to the brick wall, but I don't know what to believe without a licensed survey. I'm not going to take for granted the sections provided by the architect, who didn't seem to know that the project extended past the property line and didn't seem to know, without our pointing it out, that the parapets may have exceeded the maximum heights. So either it's done by a licensed surveyor or I'm not interested in the architect figuring it out on his or her own. We have a revised DOB objection that includes the unpermitted obstruction in the front yard. There's also a restrictive declaration that we expected, and I don't know if our counsel has been able to review it. I'm a bit confused myself by the terms of the restrictive declaration, which has to do with events in the cellar, kitchen. We were told no events would be, we were told by the applicant prior hearings that no events would be held in the cellar, hence no need for a kitchen. That's why they were taking everything out, right? That's not at all what the restrictive declaration says. It allows for leasing by congregants for, quote, small life events. What's a small life event? There are 440 congregants. That could, according to the restrictive declaration, mean being leased every day of the year and add some more days in the year because there are more congregant than days in the year. So what about the restaurant lease that was supposed to cover all of the needs for on-site activities and use of a kitchen? All of this, frankly, underscores my suspicions and the reasons that we're so let's say, uncomfortable with this application. To add fire to all of this, or let's say oil to the existing fire, the restaurant lease is with, quote, BJC Gourmet LLC as tenant, not with the synagogue, right? And it leases to that LLC either for 5 or 10 years, depending on how you read the lease, which is very inaccurately filled out. And it's read as they're supposed to be leasing it as a, quote, kosher restaurant. So who is this LLC? What does that have to do with the synagogue not using the cellar to host events as it is supposed to be promising? The lease provides no indication of the size of events it can accommodate or the frequency or duration of use. I really have no idea what I'm looking at, and this gives me less comfort than I had before that the retention of the walk-in refrigerator will not soon lead to cellar events on a significant scale and frequency that amounts to commercial banqueting and catering. So I'm back to kind of not believing anything. I don't like to have to guess like this, but when we are handed materials to tell a story different from what we were promised by an applicant who has misused the board's grant in the past, what's our option? An operational plan states that the usual events in the cellar accommodate up to 70 people with food. To make this work and for the benefit of the neighbors who are most affected by non-compliant behavior, the restrictive deck must specify occupancy in the cellar, off-site cooking, and frequency of events not to exceed something reasonable. I'm just so confused because we were told the ceiling is too low, we can't have events in the cellar, we're abandoning the whole thing. We can't take out the walk-in refrigerator because it's too big to take out, so we'll leave it and we'll use it for storage, whatever, right? A separate floor area calculation sheet was provided for the second floor, but I don't know what it is since it looks nothing like the floor plan and it's just kind of floating there. I'd like to know what the status of the ECB violations are and the status of fire department review, because fire department was checking on illegal occupancy and so on in this building. Yeah. Vice Chair Shanda?
Okay. So with regards to the property encroaching onto the city sidewalk, I would like the applicant to provide a proof that indicates that the wall existed prior to the sale and prior to BSA approval, because the prior BSA approval plan does not include it. So, and I don't know if the prior BSA approval plan required a survey or not. For one, if they want to keep the wall there, you know, that's for them to get the approval from DOT to seek the necessary permission that they have the authority to do that. I would also suggest at that same time, they plant that remaining portion of the city area with greenery if they cannot do it on their property because of the cellar situation. then they use that portion with all the planting requirements that we would ask for, because if DOT is going to give them the authority, give them the go-ahead to keep that wall, they should be able to give them the go-ahead to plant that portion also. So that would be one way of circumventing, addressing the planting at grade. With regards to I had asked them to provide the explanation of the parking waiver, why that would not change with the change in the occupancy. I was satisfied with the explanation that was provided, and the justification that the applicant provided with regards to the maintaining the existing arc as an encroachment in the front yard. I was satisfied with that. I definitely did not understand I did not look very closely at the lease with the commercial space, Madam Chair, that you are referring to. I'll defer to you on that. That is your expertise. But those were my comments.
Okay, thanks. Commissioner Otley-Brown?
I agree with the chair that it's problematic to keep the refrigerator and the walk-in freezer in place, even though that they say they're going to use one for refrigerated waste storage. Being that they installed it illegally to begin with, I don't have much confidence that they're going to use it the way they say they use it, especially if they're going to continue to have events. Just to say that you're going to have events in which 60 to 70 people are going to attend, that's impossible for us to monitor. We don't, it's a congregation of.
Oh no, you're frozen again. You're frozen. So she's having the problems that we had. Everyone can hear me, right?
Yes.
Yes.
So Kurt, can you call her again, please?
Yes.
Thank you. Maybe while we wait for that to connect, we'll go to Commissioner Sheta.
Thank you, Chair. I don't have anything further to add, except for saying that I'm okay with the encroachment of the arc into the front yard, because this is kind of condition that they realized that it's not satisfactory to the DOB, and I believe my understanding is they added this as an objection, so it's going to be an additional waiver, and I'm okay with it. But I agree with all the comments you mentioned before.
Hello.
Hi.
Yeah.
Sorry about that.
That's okay. Oh, you're back on Zoom. Okay.
Yeah.
So that was Kurt calling you to connect like that. Okay. So I'm just catching you up. We went to Commissioner Sheta, who is okay with the encroachment and agrees with the prior comments. So let's go back to you. You were mid-sentence.
Right. And I was going to say that I would feel more comfortable if we didn't allow any events of any sort on the premises, and that they would use the restaurant solely.
Hmm. Right. Okay. Anything else?
No.
All right. And Commissioner Sheta, that was the end of your comments?
Yes.
And Commissioner Shibeta?
Thank you, Chair. I understood from the last hearing that the plan was to only use the restaurant. There weren't going to be parties in the cellar. And I think that the only way that, notwithstanding the other issue of there being an encroachment on city property that I think they have to address, the only way I think that this board can be satisfied is if the changes made are structural ones, actual concrete, actual removal of refrigerators, that we can be ensured that they're going to act appropriately, because the story keeps changing, and I have in my notes quite clearly that there was to be no parties in the cellar. That's all for me. Everything else that was said, I agree with you.
Okay. Thanks, everyone. Surprising, right? Okay.
New
Right.
case. Oh, I'm sorry, Madam Chair. Move on.
A quick question. Should the restrictive declaration refer to the offsite location as the location for events, and specifying that no event shall be held on site.
Yes, yeah. And so, my only problem with this, just to get it out there, is houses of worship usually do have like little, teas type thing after an event, after a prayer service, right? So to restrict totally the idea that they would have anything is tricky. However, it was represented to us that the cellar wouldn't be used for anything because the ceilings were too low. And then all of a sudden we're putting 70 people in it. So maybe the issue would be that in the sanctuary space or in the other space, that's where a maximum of, say, a gathering of 40 or something like that, or 30 would occur, and anything larger than that would occur off-site. And then to have the occupancy limited. So, you can do that with the building code where occupancy is limited to this many persons, so that a room is created where occupancy is limited to that many persons. I agree that you can't monitor it, but if the room is so small that you can't have more than X many persons in it, maybe that's a way of ensuring that we're not sort of facilitating what the neighbors feared, which is again, continuing the kind of banqueting.
Hey, Chair, please.
Uh-oh.
Yeah, I was waiting for you to comment on the freezer and refrigerators. I'm not an expert when it comes to these kind of stuff, but I'm not sure if the refrigerators in the cellar, they should be removed or they can stay for use as refrigerated trash storage. I'm not sure if you can use it like a conventional walk-in refrigerator for trash storage. Is that something that's possible?
So this is an enormous walk-in refrigerator. And as we're learning from one of our following cases for the daycare center, you can have refrigerated trash storage in a little tiny thing and accommodate lots and lots of trash, right? So what they're talking about is accommodating the perishable trash for the block. So yeah, you can put, stinky trash in a refrigerator. That's basically what a refrigerated trash storage is. But they'll have, 2 bags in a corner, and then the rest, if our suspicions are held out, will be boxes and boxes of food that's going to be prepared, food that arguably is delivered from the restaurant and has to be kept cold before it's warmed for an event that's going to be in that space where there was supposed to be no event. So I think that's what the problem is. And as Commissioner Ollie Brown said, they were never allowed to have this. And they went ahead and they did it. And they did all of these other things without permission, which I doubt would have been given by the board that reviewed it in the first place. So, okay.
Move on.
Yes.
Next item, new cases, item number 18, 80361 BZ, 1416 Highland Boulevard, Staten Island.
We have proof of service of initial application and notice of hearing to officials. Community board waived the recommendation. This is both an extension of term and appears to be a legalization, or correct me if I'm wrong about that, of conditions, including added convenience store and tire storage enclosure. The application does not specify this. If it is a legalization, then the compliance report is wrong. And I believe there's another fee when you're making an amendment. So jump in, Carlo, if that's the case. They should provide current photos of the site without the construction fence obstructing the site. Photos should be details of the perimeter conditions going all the way around the site, taken from inside the site and to the extent possible outside the site as well. This site is bordered on 2 sides by residential uses, but makes no effort to shield the commercial activities from them. No landscaping is proposed. Sorry. no landscaping is proposed on the side lot line that is coincident with the rear lot line of residential properties. Instead, the proposal is to put the dumpster and tire racks in that area. So there needs to be landscaping along those side lot lines. Okay, Vice Chair Shanda.
Thank you, Madam Chair. I had similar comments. While there is existing landscaping along one of the side lot line that abuts the commercial, abuts a commercial use, and it's in the commercial district. However, I agree with you that landscaping needs to be provided, a better buffer needs to be provided along the lot line abutting the residential uses. Because along that lot line, as you pointed out, not only do we have the trash enclosure, the tire racks, we also have the air pumps and the vacuums, and there are 5 parking spaces that are right up against that against that side lot line. So I think landscaping can be provided along that and allow for that buffering. In addition to that, I would suggest that the air vac and the be located along the lot line, which is adjacent to the commercial use and not along the residential use. The applicant has not provided the signage analysis per street frontage. They need to break it up by street frontage. And also, I believe the photo that we have on our portfolio in our SharePoint, it shows that it's under construction. So I don't know if there has been any new progress that's been made. So would like an updated photos of the work that has been done so far.
Mhm.
That's all.
Thank you. Commissioner Otley Brown?
Madam Chair?
Yeah, go ahead.
I just looked over the papers. I don't know, at the time that the application was filed, I didn't notice anything that was requiring an amendment. Maybe the applicant could speak to it. I'm not sure if there's any disconnect between what's on the ground and the papers. But it appears it was filed only for the extension of term.
Yeah, but so we never approved, there's a convenience store, which was never approved previously. And I think there's, what else?
I mean, the language I could see in the statement, it appears a little confusing because it's citing the requirements of the TPPN, which just read as a proposed convenience store shall. I just don't know if it was ever approved.
No, so I know from reading the resolution, it was never approved, and looking at the approved drawings.
Okay.
There was never a convenience store, and they're also proposing to build an enclosure for the tire storage, which was never on the drawings either. So both of those are amendments, if the way I understand
Is
it.
that an enlargement to the building?
I think it's an outdoor enclosure,
Okay.
but
It's an open enclosure.
yeah, but nonetheless, it's a change to the site plan.
Yes.
Okay. So that would be an amendment, right?
Yes.
Okay. Is there another fee?
Yep.
Yes.
All right.
The amendment, just the convenience store itself is an amendment fee.
Mhm. All right. Thank you. All right, Commissioner Otley Brown, sorry.
I agree with the chair and the vice chair that there needs to be landscaping adjacent to the residential lots, and that the air machines and the vacuum should be moved to the commercial lot line.
Thanks. And Commissioner Shetta.
Thank you, Chair. I'll focus on the lighting diagram. Looking at the lighting diagram, I'm not sure what kind of methodology used to develop that diagram. If you look at the southern eastern corner of the site, I'm sorry, hold on one second. It is right. No, that actually the southern western corner of the site. You can see that next to the LED mounted light, in front of it, it's 25.5. And like right next to the property line, it's dropping down to 0. If I'm looking at a mounted light like the wall one, with the picture that's put on the drawings. I would tend to believe that with the wall mounted light, because the direction of the light spread is away from the property line. But if you look at the LED, the pole mounted LED light, it's it should shed the light like to the front and to the rear of that pole mounted LED, and to the right and to the left. I don't see any special shielding for that. So I tend not to believe in all the lighting values along the property lines. They just, I believe my guess is they just spread 0 along the property line, which is not gonna like fly with us. So I would ask them for either more reasonable analysis until they come up with measurements, or if they already installed the new lighting, they could just do field measurements per our administrative knowledge.
Okay, thanks.
And I disagree with them on the consideration that
Uh-oh.
We're losing your voice. Volume, Commissioner Sheta, volume.
Is that okay?
Yeah.
Thank you. Forgive me, this is the first time it happens. That tire rack enclosure, I don't like it to be enclosed in like kind of a PVC fence. If they want to put tire racks, I'm okay with it, but they should either put them inside the building or probably enlarge the building and make that tire rack enclosure something like indoor, as per the notice of comment mentioned. That notice of comment requested them to put the tire racks indoor, and their response was, we're creating this tire rack enclosure from PVC material. I don't think this is going to be respectful to the adjacent residential.
Okay. Okay. And Commissioner Shibeta. I see Commissioner Shanda's hand up. I'll come back to you.
Thank you, Chair. I agree with the comments made by the other commissioners, particularly with regard to landscaping and the moving of the air pump and vacuum to the commercial portion. I also second Commissioner Shedder's comments, and I believe that I was looking at the graph as he was speaking, and I believe that field measurements may be the best way to go now. Nothing further from me.
Thank you. Commissioner Shanda?
Yeah, I was trying to follow Commissioner Sheta's comments with regards to the lumen count being high along the southwest corner, if I understand correctly.
Yes, if you go to the bottom right-hand
Right.
side corner.
Right, it's 25.5. That's
And
the one
then
you're
right next to the property line, it's dropping to 0.
right. First of all, I think there are street lights along this whole street frontage of Highland Boulevard, and from the photos that I seem to recall. So even if their count is showing 0, there are street lights, and this is a commercial frontage. This is zoned for commercial use. So based on their analysis, they might be saying that their count from their light is 0, but it could be in reality, I would think it is more than 0, because it is right along the property line where there are street lights. So it's the city street lights also that's casting a lot of light along that. So I'm not sure to what extent we should use that. And we have in the past been more accepting of a higher lumen count outside the lot line when it's fronting a street. It's only when it's fronting abutting a residential property is where we have been very strict about the 0 count. So that's why I'm trying to understand the concern here.
Okay, I'm looking also.
Isn't the property next door is a residential property?
It's a commercial.
No. It's described as commercial, but what it is it's ground floor commercial.
Yeah.
And the upper floors are
It's residential, yeah.
mom and pop type thing. So the upper 2 floors are residential and the ground floor is commercial.
Notwithstanding, I think that if they submit something to us, it should be accurate. Whether we should know what the lighting is on the border. It shouldn't be something that, and then we can decide. Upon discussion and upon review, we can say, well, cost benefit analysis, does it make any sense? Perfect. But if it's going to be submitted, we shouldn't be picking out errors like that. We shouldn't be picking out something like that.
Yes.
Thank you, Commissioner. Thank you.
Yeah, I agree. And the jump is so significant. We've talked about this before. How can it go from 16 to 0 in 4 feet? And
Yeah.
that's the reason why the administrative notice is so great. It says, turn the lights off, turn the lights on, and then you know what the delta is. But I doubt that there's a light source coming from the little place next door that would bring it up to 13, right?
No, and it's usually not considered when you do this kind of like analysis, the theoretical analysis. It doesn't consider the street lights. It doesn't consider the lights coming from the adjacent property. It just consider, you put the data, the information for the light poles that you're installing on site, and you get what is coming out of these units. And my point, if it's what's coming from this unit is 25.5, right below that light pole, 2 feet back, it shouldn't be 0. It's not going to happen. There is nothing that could even be close to 0, even if there is shielding, perfect shielding, considering the height of a light pole, typical height of, let's say, 15 feet or even 20 feet. It's going to be like the Mission Impossible to get it to 0 from 25 and something.
Right.
It's not going to happen.
And the drawings do say that it's with a proposed light shield, so they don't have the shields installed, of course. And unless we saw, for example, if it had to be modeled, that's a perfect case of needing to see the cut from the fixture with a shield installed, with the manufacturer's test results that show how the lumens are spread, which is those curvy little diagrams that show in 2 directions the direction of the light caused from the shield. Because at some point, the shield is not going to be effective. It may be affected at the beginning of the light, but not at the bottom of the light where it hits the ground.
Yep.
Right. Okay. All right. Thank you, everybody, for that. Commissioner Shabeta, did you finish? Yeah.
I did, thank you.
Okay. Any other comments on this? All right.
Okay, next new item is item number 19, 14166BZ, 338 East 9th Street, Manhattan.
We have proof of service of initial application and of notice of hearing to officials. Community board waived its recommendation. The drawings indicate that the front portion of the building is for, quote, parking and motorcycle sales use group 16, unquote. This is not mentioned anywhere in the statement of facts nor in the prior resolution, so I would like them to explain that. So yes, that's my really only comment. Apparently it's been motorcycle garage for decades, but not about sales. Okay, any, Vice Chair Shanda?
I had no comments on this application.
Okay. Commissioner Otley Brown? You're muted.
Muted.
I just had one question regarding the plans. The previously approved plans showed a door in the side that went to the next door garage, yet it's no longer in these proposed plans. So did they get rid of the door, or is it still there and they need to put it on?
Thank you. Sorry, 1 second. Commissioner Sheta?
Thank you, Chair. The only comment I have is regarding fire safety. I'm not sure is there any fire safety measures in this garage, since motorcycles are going to be stored? Are there any requirements, I would say, for fire safety measures to be taken? And does FDNY need to take a look at it?
Okay. Well, FDNY is hearing us, so we'll have them comment at the hearing. Storage. Okay. And Commissioner Shabeta.
Nothing further from me, Chair.
Thank you.
Okay, next item, item number 20, 31377BZ, 1200 Broadway and 17-27 West 29th Street, Manhattan. This is a review session. Please do not call in.
We have proof of service of initial application and of notice of hearing to officials. Community Board 5 provided a very detailed recommendation to deny, citing the negative impact on the neighborhood of a very tall tower on the development site that would be facilitated by the subject development rights transfer. We have testimony from many residents of the subject building and other organizations such as the New York Building Congress, Manhattan, and Manhattan Chamber of Commerce in support of the application, because the income from the sales of the TDRs, the transferable development rights, will enable restoration of the facades of this New York City landmark. We also recently received a letter in support from the council member, I believe. They and the revised statement of facts state that the 30,570 square feet TDR transfer represents the addition of 2 stories, but actually when you look at the drawings, it's 2.5 stories to the project. But the drawings indicate that TDRs are 31,156 square feet. So there's a disconnect on the kind of internal materials. I just want to clarify what amount they're actually talking about. Fire department provided an email on July 12th and is okay with this application. This application is very similar to others we have seen over the last 20 years, or the board has seen over the last 20 years, where TDR transfers have become common practice and assemblages of very large zoning lots to facilitate them ubiquitous. Like many other applications, this one pertains to a use variance granted in the late 1970s in an M district when new hotel and office development was non-existent, nor were TDR transfers common. Until the year of the grant, the receiving and granting sites had to be in common ownership or under long-term leaseholds. The applicant has gone through the tests in the Bella Vista case, and it is clear to me that the conditions here are nothing like those in that case, where the Bella Vista property was held in common with the receiving site at the time of the variance, and the transfer proposed to take place within a short few years, actually 3 years, of the grant. Hence, it would have been a windfall had both the variance and the transfer been allowed. In this case, there's been almost 40 years since the 1977 variance grant, and as discussed above, no known market for or even awareness of the value of TDRs existed at the time. With respect to the details in the application, I just want to go through cleaning up the application. The zoning analysis on the proposed plans needs to take into account the new zoning lot size. Luckily, I believe that on Friday, so October 1st, there was a submission that does that. So commissioners should note that submission. If they haven't already seen it, they may have reviewed this case before Friday and might have missed that submission. The calculated floor area on the new drawings on T001 is for less total floor area than was permitted by the BSA in 2012 and in 1977. So in that time, it was 112,579 square feet. And what is being discussed here is essentially 108,431 square feet, because 1,000 square feet is being reserved by the property owner, let's say the transferor, for future use or to make up any gaps. There is an inconsistency among the submissions about how much floor area is being retained and or is existing at the subject site. The October 1st set says 108,594 square feet. And I had another that said 107,431 square feet plus 1,000 reserved, both of which are less than the BSA approval in 2012 and 1977. The statement of facts indicates that the lot area as shown on the 1977 approved plans was incorrect, although the meets and bounds have not changed. I'd like to know, was a new survey conducted, and in which case they need to provide it with the surveyor's calculation of lot area. I'd like to know, was a professional survey of the existing floor area also conducted? And if so, that should be provided. I do note that the architect who is working on this is a very sophisticated firm that does a lot of complicated projects, but I don't know if they're the ones who cannot conduct the survey. Usually that's not done by the architecture firm, but an outside surveyor. We are being asked to agree to or accept the total amount of floor area available for transfer. I don't think that's the role of the BSA to do that. The lot area is determined by a surveyor, as is the existing floor area, and the rest is contractual between the TDR buyer and the seller. And if the numbers are wrong, then sort of they take that up in their dispute. If BOB doesn't agree with those numbers, then the deal is adjusted accordingly. Nonetheless, I have questions about the submitted calculations since they reflect changes to the 2012 and 1977 approvals. So I'd like them to explain the statement in the statement of facts on page 11 that the third floor of the subject building doesn't contain habitable space and hence is not zoning floor area. There is a typo on that paragraph, probably intending to be the word insufficient, not sufficient, to qualify as habitable space. And the statement actually may have been intended to refer to the third floor mezzanine, but I find nothing in the zoning resolution find nothing in the zoning resolution allowing floor space with floor to ceiling heights under 7'8" to be excluded from the definition of floor area. That's like a very old concept that existed, I don't know, in the 80s, that mezzanines that were under a certain height didn't count as floor area. That was taken out of the zoning resolution, if it ever existed at all in the zoning resolution. The only height exclusions I am aware of pertain to attic space in low density zoning districts. The 1977 to 2020 comparison diagrams show no third floor mezzanine. Is the language simply unclear and the mezzanines never built, or are we talking about mezzanines with low ceiling heights that are just not shown on the drawings because they say it's not habitable? Explain also whether anything at all was built on the lower penthouse. The 2020 comparison drawing shows that it is mostly bulkheads that arguably wouldn't be floor area, but then wouldn't these just be extensions of existing stairs and elevators and nothing new? And what are the many open to belows at the penthouse level that aren't reflected in the floor plan below and somehow aren't bulkheads? I actually have a lot of trouble understanding what is up in that penthouse, what was actually constructed. So if they could provide a clear architectural plan of the penthouse and indicate the areas that they think are exempt from floor areas. What was provided was really a diagram and it's hard to understand. They should provide the floor area calculation diagram sheets that calculate the zoning floor area of this irregularly shaped building, not only the calculation sheets of the deductions. So we're only seeing an assumption of total floor area of the building, and then where there's no measurements taken and no little kind of ABC boxes for the actual floor area. And so they take that entire floor and then they measure all those little deductions and they add those up and they subtract it from sort of an assumed floor area of the main building, but we never see the floor area calculations for the main building, the diagrams. And I just want to, because this used to be my, one of the things that I did for a living, I'd like to alert the Gilsey House owners that the developers who are purchasing these development rights are cutting the floor, and I'm assuming that all of this was done by the developers in terms of the calculations, because it's not usually done by the seller, it's usually done by the buyer. That the developers are cutting the floor area calculations so closely that every bit of mechanical deductions that could be taken are being taken, including pipe chases and trash chutes in the walls and the little openings in the winding stairwell even, and the trash vestibule. This may mean that even interior renovations that attempt to reclaim those mechanical areas in the future, or reconfiguration of a stair or trash area that would convert deducted area into floor area, will not be permitted. And also that no mezzanines, as appear to have been desirable additions to individual units in the past, will be possible in the future. In my practice as a land use lawyer representing development rights sellers, I would always caution them not to cut their futures to the bone. So it's not something that's within the BSA's purview, but I really do caution the sellers not to be so tight with this. Okay, Vice Chair Shonda?
Hi, okay. So I agree with you, Madam Chair, that the applicant meets the Bella Vista test. And given that, all the other sites in the area have been given the right to, they have the as of right to transfer the unused floor area, so should this site, but for the variance. And we are just here to ensure that the variance that was granted does not in any way affect our findings from the prior case, and the Bella Vista kind of is the test for that. I have just a couple of comments with regards to the submission. I noticed that in the community board submission package, the applicant had submitted a floor by floor analysis of approved floor area, built floor area, and the difference. I didn't see that chart in our submission, and I thought that was very helpful in trying to follow where there has been, what has been built per approved plan and what has been overbuilt or not built. So I believe from the comments that we are receiving so far, there would be need for some revision, and I would appreciate it if the applicant can provide similar table with the correct set of floor area in the column that is approved by BSA, built since then, and the differences and the proposed amount of floor area from each floor that is going to be transferred to the total amount. I think you mentioned there.
Just before you say that, did you check the submission that was just made on Friday, the 10-1 submission?
I
had that.
I downloaded it and I didn't see it, so that's why.
Okay, because I think I could be mixing it up, but I think there was a very large submission made that had a ton of exhibits attached to it, and you had to scroll all the way down to maybe the last page to find the comparison drawing, I think.
Okay, let me, I have the exhibit. I'm looking.
All right, anything else?
But I think that really was just my comment.
Okay.
Otherwise, I'm fine with this application.
Commissioner Otley-Brown?
I think that the financial letter was very clear and helped support that this was not a case akin to Bella Vista. They did not consider the value of the unused development rights in 1977 simply because it was too early in the whole idea of zoning development rights coming into fruition, that hardly anybody used it. It was too new. Developers didn't know how. Not only that, the area was considered undesirable at the time, and there was a lot of unused, vacant, available manufacturing space anyway, so there was no market for it as well. And not only that, even if there was a market for it, there were no viable options in terms of receivers for the transfer of development rights, because all of the surrounding lots were very small and would not have been able to make use of the development rights. It would yield too small a floor plate to be viable. So I'm satisfied with the application as is.
Great, thank you. Commissioner Sheta?
Thank you, Chair. First of all, I want to say that I did read in the statement of facts that it says tax lots to be merged meet ZR 10 feet contiguity requirements,
Yeah.
and the proposed office building complies with applicable bulk regulations. And so they consider that the development rights transfer from the site will be as of right. If it is as of right, they wouldn't be here. They could have done it without coming to us. So my understanding, I'll take this as it's going to be used for an as of right use, which is commercial. It's not going to be transferred to residential or something like that. But the transfer process itself is not an as of right, and that's why they are here. This is one thing. The other thing actually is that my understanding is when they came to the board back in 1977, they came for two things. Number one, a use waiver. The variance included use waiver, plus I believe in 1990.
Well,
In 2012, yes, I'm sorry. Yes, 2012, they came back for an enlargement. And if you look at this, between 77 and 2012, that time span is not a short time to test the variance granted back in 1977, whether this variance was the minimum variance or was not. And I got the feeling that based on that enlargement granted in 2012 and what happened even beyond that, after that, that the variance granted back in 1977 was not a minimum variance, maybe. I'm not saying this for sure, but I got the feeling that it was not. If this is the case, I believe one of the concerns in the Bella Vista case was to make sure that the variance that was granted in the first place was a minimum variance. And if it wasn't, that should be considered in looking into allowing this transfer to take place. That's all. Thank you.
no, I just want to correct that, and I see the shaking of heads of Commissioner Otley Brown. And I see Jella Pranga's hand up, which I'll recognize in a second. I want to clarify something. So the first is, in 1977, these are very common variances in the 70s, because it was all around the time of the loft law. So there were a lot of buildings in this area that were becoming residential through the loft law. And then there were others that weren't succeeding because through the loft law, or they wanted to convert the entire building or something like that. So this one was a use variance for what was originally built as a hotel, right? And that's all it was. And the amount of floor area that existed on the site was allowable, like it didn't exceed the allowable floor area. When they came back in 2012, that was simply an amendment, which is what's required, to the variance from 1977 to update the floor plan, because the floor plans must always look like the variance, to allow something that was as of right as to that, to let's say not as of right, to allow an enlargement where the floor area already existed on the lot. So they weren't getting more floor area, but what it was allowing was a use waiver of that additional floor area for the penthouse, which ultimately either wasn't built or was built very little. It's kind of hard to tell from the paperwork. Okay, so, and in terms of the minimum variance stuff, it's at the Bella Vista test is only looking at a windfall situation, right? The board is supposed to be granting the minimum net variance necessary to afford relief. So presumably that's what happened both in 77 and in 2012. but Bella Vista only looks at, did you sort of make a killing in the market and then you get to do it again? Or let's say you got a variance and got made whole, and now you're being offered a killing in the market, which puts you way over and advantaged over everyone else. Commissioner Otley Brown, you want to add?
I wanted to say that Bella Vista has to do with whether or not also we were overlooking a significant source of value at the original variance. It's not reopening the 5 findings all over again for an analysis as to whether or not back in 1977 they granted the minimum variance. It's that, did they ignore a significant source of value or a significant income stream? And so the analysis is really tailored just towards that. And it determined that back in 1977, there was absolutely no market for those development rights. And anybody who lived in New York City at the time, it would have been a no-brainer for you. There was nothing going on in this area of Manhattan that was very productive or a good investment source.
Right. Thank you. Ms. Pregna, you want to add something?
Yes, you were making reference to a large submission that came on Friday, and I think there's a little bit of confusion about it, and maybe the applicant can clarify, but I believe that submission was the material they're going to present to you today at the hearing.
Oh, okay. Well, so those of us who saw it reviewed it, so we didn't know it was not to be reviewed. But anyway, it had new material. So, okay. All right, thank you. And I also just want to pick up from Commissioner Otley Brown's comments. Famously, I believe it was the year after, was a decision on the Grand Central Station case known as Penn Central, which was the case that had to do with, which essentially preserved the landmarks law. And the whole concept of it was that the Grand Central Terminal that wanted to build a tower on top of it was prevented from doing that by the Landmarks Commission. And the court said that landmarks preventing you from doing that is not a taking, because you could sell the development rights from the Grand Central Terminal building to initially, when the case was sort of in its early stages, to adjoining sites that Penn Central also owned, and then subsequently the zoning resolution was changed to allow it to be not in the same ownership or leasehold. So it was really just beginning to be understood that you could even do these things. So it wasn't even just this neighborhood that was unlikely to have any receiving sites or even buyers for any amount of money. It was basically the whole city. I don't know of any projects that were done at that time using development right transfers. Maybe there was maybe some of the lawyers who are presenting on this case know about buildings that might have benefited in the mid 70s from that, but I don't know. Okay. Any other comments before we go on?
I don't think I was given opportunities.
I'm sorry. How did that happen? You should have looked in.
I didn't want to get caught up in the fray.
Okay. Yeah. Okay, go ahead.
Very well. So I believe that we did speak a bit about the Bella Vista test. I agree with the board that the concerns in Bella Vista are not apparent in this case. I don't believe that the conveyance of the variance of unused development rights could have been foreseeable at the time. I think that part of the reason for that is, as was said, this was approximately 40 years from the time of the transfer, different owners of this lot and the adjacent lot of different owners. And back in 77, this wasn't exactly something that was considered. Taking that into effect, I think we should also consider that the type of where this property is, as Commissioner Otley Brown stated, how it was not a desirable location at the time. And that's not akin to what it was in Bella Vista. I think the only other thing that wasn't mentioned that I think has some value is that these, this is now the use is now an as of right use in that area. And I think while I don't want to get into that too much, but I do think it's noteworthy.
No, wait a minute. We're talking about hotel.
I believe
Hotel?
that
Hotel use is no longer as of right.
So it was built as a hotel,
Yeah.
and then the use variance that was granted was to allow residential use. And the residential use is still not permitted in M zone.
Right. So to go back a little bit, the building was built in the, I think it's either the early 20th or late 19th century as a hotel, like kind of a grand hotel. Then it was converted to office use that it for which it was not suitable. And then the property, let's say the resident applied for this variance to allow to be converted back into residential use or to residential use, which is closer to a hotel use. But as of, what is it, 2 years, hotel use is not an allowable as of right use anymore in M districts.
Right. It was built in 1871.
Wow.
Okay.
That's it? Okay, this concludes the review session. We'll now commence with the public hearing. Good afternoon, public hearing, Board of Standards and Appeals, October 5th, 2020, 2 p.m. session. So the first case is continued hearing item 17-2308BZ, 80-14 Chevy Chase Street, Queens. The applicants for that case, please call in, or if you're already in. Whoa.
I'll have to mute.
Okay.
Mr. Noriega, state your name when you can hear us.
I'm here. Richard Lobel from our office should also be joining.
Okay.
All right, who else? I see a couple other people. Are they with your team?
Joshua Levy is from ownership, and we have Philip Toscano and Eduardo Escobar from the architect's office.
Okay, I don't see Philip.
They may be joining together.
Okay, okay.
Wait a second before you do that. Mr. Levy, can you hear us? And if so, state your name.
Yes, hello, everybody. I hear you. Happy holiday to everyone.
State your name, please.
You hear me?
State your name.
Oh, Josh Levy, thank you.
Okay. And Mr. Escobar, could you unmute yourself and state your name? Mr. Escobar, please unmute yourself and state your name. Okay, not doing too well there. And Mr. Lobel, could you state your name, please? Hello.
Of course. Hi, Richard Lobel, Sheldon Lobel, PC for the applicant.
Okay. We're not, so in terms of swearing in, I don't need to testify, then we're going to need him to swear in separately because it doesn't seem to be hearing us. Okay, Tony?
Understood.
Okay, so who's ever present, please raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Yes.
Please proceed.
Thank you, Chair, Commissioners. Once again, Richard Lobel of Sheldon Lobel PC for the Bakarian Community Center. Chair, Commissioners, we listened to the board's comments. We have Josh here to answer some of the issues which arose from the standpoint of the operations of the shul. Mr. Noriega and Mr. Escobar can speak with regards to some of the construction and other conditions existing on the building and particularly with regards to lot lines. But I would just start with one discrete point which the board raised with regards to events. And we now, and I think that there's areas where we understood that we were able to clearly and convincingly comply with the board's request. For example, the kitchen has been ripped out. We've supported this condition. The issue that we have is with the potential discussion around total elimination of space within the building for life events. And I think the chair hit on something on her conclusory remarks towards the end of the executive session, which said that there was a question as to whether or not it was legitimate to ban all such events from the structure. We would say it is not legitimate. Importantly, as a religious organization, this organization receives special benefits under the zoning law and from this board. And, you know, we quote case law all the time and it becomes an afterthought and put into statements of facts. But the truth is, matter of Westchester Reformed Temple versus Brown, the Court of Appeals case, which was cited here as decided by the court in 1968, says that, quote, we have not said that considerations of the surrounding area and potential traffic hazards are unrelated to the public health, safety, or welfare when religious structures are involved. We have simply said that they are outweighed by the constitutional prohibition against the abridgment of the free exercise of religion and by the public benefit and welfare, which is itself an attribute of religious worship in a community. The potential elimination of life events from this building in the form of, for example, Brit Milot, which is the prayers and the ceremony of a male circumcision when a child is 8 days old, as well as for other smaller events, which, understanding that while we typically think of things like bar mitzvahs as large events, these can be and often are in religious settings, smaller and intimate events, their elimination from this building would be nothing more than an unconstitutional prohibition on the free exercise of religion in this building. I would add that, and again, we're happy to discuss some more of the substantive issues, but that the prior board, when hearing this case, and I have the benefit, of course, of having represented the synagogue at those hearings 15, 16 years ago, they did consider the fact that there would be these life events in the building. They were discussed as being up to, let's say, 40 individuals who would attend these events, but it was not that the board failed to consider that, and so it cannot now be included in the building. This is something which is very important and was considered by the board and indeed engendered some of the issues behind why a parking study and other studies were done. So I'm not sure whether or not Commissioner Otley Brown is making some sort of.
Yes, go ahead, Commissioner.
Yes, I wanted to say that, yes, you're absolutely right. It was considered that we would allow small events, but that was prior to the synagogue going against the BSA approved plans and installing a full commercial kitchen with a huge refrigerator, walk-in refrigerator storage and freezer. And the board was very specific at the time that they did not want any commercial catering on site or any large scale food serving events at this site because it was too small a site for that intensive a use. I was on the board at that time. And so now that you've put us in a position by first building not according to plan, but also requesting that you leave in place 2 rooms that actually can support a large scale event serving food, that makes it very difficult for us to have confidence that you're going to limit your life events attendance.
Thank you, Mr. Otley Brown. In response, the board, and again, both from the prior case as well as from my experience with dozens of applications for synagogues, the board essentially has separated events that take place in the synagogue into 2 types. One is life cycle events, and the other is functioning as a use group 9 commercial catering hall. And in the event, and there are synagogues which have operated in mixed districts, for example, where commercial catering halls have been permitted. This is not one of those. But a commercial catering hall, it is agreed that a use group 9 commercial catering hall was not contemplated or permitted by the board and could not function in this building. And so you are correct. The ripping out of the commercial kitchen or the large kitchen, while I would not concede on behalf of the applicant that was what was taking place here, the truth is, you're right, it had the physical attributes of being able to take place here. So the board has never condoned use group 9 catering halls as operating in a synagogue. And this essentially, that involves preparation and essentially operating as a kitchen on the site. So that's not sought here. So what's sought here now is the ability to conduct life cycle events. And all I'm saying is this, and again, this is a discrete point. I don't want the board to view this as an opportunity to remove from the applicant the ability to have life cycle events in their building. This is a very important part of their religious practice. And the understanding that they may have operated in the past and that the physical facility for operating as a commercial kitchen has been removed. Now we're in a position of what happens next. So I would say two things. The first is that Josh can talk to the fact that the surrounding neighbors have come to an understanding with the synagogue, and there is actually a good relationship now when there was formerly a bad relationship for years and years. But importantly, on an ongoing basis, the board is, to the extent that it shuts down the ability for life cycle events, it's problematic. It's, we understand that there was an issue there where, why did they do this and what did they do in the past? My concern is that this bleeds over to, well, this applicant operated poorly, so we're going to shut this down forever, when indeed that is an issue of enforcement and the inability of an applicant to do that. Any applicant who wanted to could rip out their cellar and put in a commercial kitchen. This would be contrary to law. The applicant wants the opportunity to work in accordance with law, in accordance with the board's grant, and understanding the truth of this. We just would severely oppose any opportunity to fully restrict such events from the synagogue in the future. It would be a huge impingement on their ability to conduct.
We got that. So what I want to say, the first part is, one of your sentences was, we want to comply with the law, in accordance with the law, right? Well, the law was the BSA grant back in whichever year the BSA grant was, because I don't have the number right in front of me.
I believe 2006.
2006. The BSA grant said no commercial equipment in the cellar, right? Which includes a walk-in refrigerator, which includes a walk-in freezer, which includes the gas lines that continue to be there, which can easily be hooked up again, no problem to do that, right? And so our direction from day one was take all that stuff out. The second part of the history before this board right now was that after representing that all that stuff would be taken out, there was a statement that said, well, actually, we can't hold any events down in the cellar because the ceiling heights are too low. So we're not even going to have any events in the cellar of any kind. So we're good with turning the whole place into a storage room. That was what was represented to us. Next, we know we get a submission out of the blue that says, well, actually, we're going to hold events 3 times a week or whatever the number was for 40 to 50 people. And sometimes when the events are more significant, it'll be 70, maybe it's 80 people, but I guess the number 70 was because there's only probably one means of egress, so you can't say 80, et cetera, et cetera. And so that shifts from ripping it all out, having nothing in the cellar because the ceilings are too low, to having 70 to we don't know how many in the cellar, which goes all the way back to where we were before. So you and your client need to get together and put together a coherent, believable narrative that persuades this board that that your client is not going to go back to, let's say, their improper, illegal ways. And that, of course, we understand that there are, following a bar mitzvah, you might have a little cookies and cake kind of and coffee, but that it's not a full catered event where they bring in everything and they set up tables and they do all of that stuff. It's different. And lots of synagogues just do that. And when the bar mitzvah is done, they move to another place, such as the restaurant, wherever that is, that supposedly there's a lease for. And that's when they have a big event and they invite their 50 or 60 or 70 or 80 or 100 people, whatever it is. And that's what has to be agreed upon here. Because no matter how much friendlier you say that you are with the neighbors were very, very, very disturbed by the prior practices. And this board is not going to deliver back to that neighborhood the same old thing. So you need to put together a coherent plan and not give us constitutional arguments.
Chair, we will put together a coherent plan. The discussion around the complete elimination of the opportunity of the synagogue to conduct these events was what was troubling.
Okay.
Okay. I think we would launch directly into considerations of,
I just want to add,
yes.
I don't get it. Is the ceiling too low or isn't the ceiling too low?
The ceiling's too low to have what we would call the typical Bukharian community events, which amount to hundreds and hundreds of people at a festival for example, a wedding. The ceiling is not too low to have a midweek Thursday morning Brit Milah for the birth of a baby. It's not. So that's the essential difference.
What's too low? What's the building code minimum requirement for having more than like the super down there?
I don't know offhand, and I would like the opportunity to respond to that. Mr. Noriega may have some insight into that regard, but suffice to say that there is a difference, and we would set that out to the board.
Okay.
Okay. I think we would now launch into a discussion with regards to the conditions that were discussed previously with the board, those which were quote unquote non-negotiable, and where we are on much of this. I think that that a presentation of the materials can demonstrate where the seller is within the lot lines as discussed. We understand the board's discussion with regards to the planting of trees. I think that Mr. Levy and Mr. Noriega are well informed on this and would have the opportunity to discuss this. I would just say that we did hear the board with regard, and particularly the chair, with regards to the planting of trees. The discussion with Mr. Levy and with the executive board of the synagogue was that there had been a tremendous amount of damage that had been done to the building itself through prior plantings, through, there was a lot of water damage, and there was damage to the structure of the synagogue. I would just have Mr. Levy discuss this very briefly before we take it up with the board.
So I don't really want to hear about bad contractors doing a bad job about putting planting. Planting is put at grade in planting beds every minute of the day of the year throughout the world, right? And all of a sudden, this one site cannot figure out how to do it. And planting beds are also placed, as I said, on top of parking garages, on top of all kinds of cellars, to the extent that the cellar extends beyond the footprint of the first floor. And so there can be above ground. I don't want to hear about the history of this improperly built building, not to mention the fact that the building was constructed not according to the BSA grant. So how are we supposed to feel sympathetic with that? So I actually don't want to have a discussion about the planting.
That's fine.
Has to be done. And the other thing that has to be done is to go back to Commissioner Otley Brown's point, because I don't want that to just fade out there. The status quo has to exist in the cellar. The original approval said no kitchen, no walk-in refrigerator, no walk-in freezer, or wherever there is down there. It all has to go. You got it in there, you can get it out of there. And I'll bet it has value. You can sell it to that restaurant that you're leasing from, and maybe they'll give you a break on the deal, on the lease. Sorry, I mean, you can't do all of this illegal stuff and then be told that, yes, go ahead and we'll trust you, because there's not a good track record here to have, let's say, earned trust. Okay, proceed.
And once you get rid of it, then there wouldn't be any concern on my part that the events would get so far out of hand.
Okay. I think we'd like to proceed. We understand the board's concerns here. I think we'd like to proceed on the discussion with regards to the seller and the as far as what falls within the property line.
Okay.
Mr. Noriega, can you address this?
Sure. So I just want to be clear that the only thing that extends past the property line is and Mr. Levy can touch on this, what we believe is a pre-existing wall that was there when the property was purchased, but it's not the cellar. The cellar extends to the property line and goes no further. It's just this wall that surrounds the property that they would like to maintain, but we understand that the board can't necessarily grant anything to do with that, and we may have to address that with the Department of Transportation.
Now, let's go back. So again, I wish that statements made by the applicant, let's say your client and consultants, could be relied upon, but they can't given the history of this site, right? So for example, a statement is made in the paperwork that a measurement was taken of the parapet wall and it was determined to be fine. The measurements weren't provided, the method for measurement wasn't provided. An architect is not the same as a surveyor who establishes grade and all the measurements and so on. So all the information that you rely on has to be provided by a licensed surveyor. It's the licensed surveyor who will determine whether the cellar was built to the property line or not. Not, I promise it's okay, trust us. It's not okay, because so far nothing has been as it appears. This is just a continuous moving target, this application. And with respect to the walls that you're talking about, you're just talking about these knee walls that are built around the property line, just assuming for a second that the cellar doesn't extend past the property line, right? If you go to the Google Earth timeline, we see that the entire site was demolished in 2009 or something. I don't know how you establish however that is, as if it were like a stoop or something that existed in the 19th century. I don't know, maybe Mr. Lobel knows at what point you can establish kind of a vested right to use of city property like you could with a 19th century stoop. That building that was torn down was not a 19th century building. It looks like it might have been a 1960s building. So, yeah. Okay. Continue, Mr. Noriega.
Yeah, so we understand that there's going to be some presentation that needs to be done as far as whether or not that can legally remain. And we understand that it's a possibility that it might not be able to, which is something that we need to address with the Department of Transportation and the Department of Buildings and prove that it is able to legally exist.
Okay. So you agree that you will get a survey, because that's what I asked for.
We can look at the, oh, Mr. Levy, if you're trying to speak, you're muted.
Oh, I'll unmute you. It was just too much there was background noise. There you go.
Regarding the survey, we just did a new survey a few months ago. What other survey you need to do?
So then the surveyor can update it. The surveyor has to go and measure the height above curb level of the top of the parapet wall and of the roof. That's one. And the surveyor has to establish where the cellar is relative to the property line. And when I say cellar, I mean the outside walls of your building. If you have vaults, if you have anything, the outside walls of the cellar and the vaults, to establish whether or not they extend beyond the property line. Ideally, they do not, all right? So if you already have a surveyor, great. It just goes in and continues the analysis.
I do have that survey, yeah.
Okay, and it needs to be signed and sealed by the surveyor.
Absolutely. No problem. Thank you.
I'm muting you again because you have a lot of background noise, okay? All right, go ahead, Mr. Noriega.
As far as the existing walls, I don't know if there's anything else to add. We will certainly be looking on that. Richard, did you want to continue with anything else? Or have me address anything else for that matter?
Just to the board's points, there's going to be a review of the in-ground planting beds, which we understand to be non-negotiable. There's a discussion of the survey. The board will have a thorough operational plan with regards to the nature of the life events which will take place here. You know, particularly to Commissioner Otley Brown's point, we ripped out the kitchen. And we understand that there are issues with regards to trust. This is still a large congregation. And while I understand that we don't want something akin to a large commercial refrigerator, to the extent that the applicant discusses that there are limited refrigerated facilities, which would be helpful to the applicant in the legal operation of the synagogue, I would actually just like speak to them about that before I say like, yeah, the whole thing can come out. Obviously, the removal of the kitchen was one thing. We understood that the applicant was in the wrong and it came out. But there are reasons why you would want to leave in at least a minimal amount of refrigerating facilities. So like, I would just appreciate the opportunity to the board of presenting that in a way which provided sufficient clarity to the board and assurances that it was not being used in a, anything but a forthright manner.
So it goes like this. I'm hosting a little coffee and cake to celebrate a bris. Okay? What do I need? I have at most 40 people who are coming to this event, right? What do I need? I need 3 coffee canisters that get delivered from whichever place because I never make that much coffee on site. It's really hard to do. Then I get a bunch of cakes that come from a place that makes cakes. I don't make the cakes. And if I need a little milk to go in the coffee, I buy the milk. How much of a refrigerator do I need? The kind of refrigerator that you have in your house.
Which
right?
is why it's understood.
Right? So a refrigerator.
If we got a bunch of waters or sodas in the refrigerator.
We're talking about taking out the walk-in freezer and the walk-in refrigerator,
Okay.
and not to make an argument that I swear I'll put the coffee and cake on the left-hand corner of the walk-in refrigerator and the trash on the right-hand corner. No.
I'm merely attempting to prevent the applicant from having to go extremely deep as far as financial resources to rip this out and put something back in.
But the applicant never should have put it in to
Understood.
begin with.
We mea culpa, we got it. I wasn't there when it was being constructed, I understand. But like, it's literally the only thing that I'm asking here is that we just have the opportunity to review that to the extent that we can save some resources. Again, we demonstrated this. The kitchen, we had a very, significant talk. The kitchen was ripped out. We get it. It's just like, I just want that opportunity. I can come back to the board and to staff in the interim, but I just want the opportunity to do that, to not say on the record right now that everything's going to come out, with the understanding that if we'd like to try to save some of the facility, we can.
But we're not going to approve it.
Well, that's the question.
We said this already. I'm not sure why we're not hearing this. I see.
Yeah.
Can Josh speak for a moment?
Yes.
Hi, Madam Chair, how are you? I don't understand why we cannot put refrigerator. Every normal family house, and when we have like 200 members praying, and every Shabbat they go down to have a coffee, not everybody in the same time, obviously doing the praying. This guy go this guy, this guy group.
Good.
I mean, why people cannot have a refrigerator in their own homes?
You could have a refrigerator. You can't have a walk-in refrigerator, and people don't have walk-in refrigerators in their own homes.
Man, but sometimes we have on Shabbat, I'm Orthodox Jewish, we have on Shabbat the brit or bar mitzvah. So the family have to bring a lot of cakes, a lot of whatever, a lot of drink, a lot of soda, and the summer they said, where do you want me to put it? That people get sick?
In the refrigerator, that's like people have when they hold a party. I hold parties for 40 people all the time, frankly. I put the drinks in my refrigerator. I do not own, nor would I want to own, a walk-in refrigerator.
Man, but this is a synagogue. This is not a private house. This is a synagogue.
But you're still limited to the same 40 people that I have. That's the point.
Let me ask you a question about why you think only 40 people. First of all, when people have a coffee, they don't drink it downstairs. They can bring it up to the secretary or outside to drink the coffee or whatever, So why do you make you feel like 40 people inside the cellar? I understand. But what about the 200 people who come to pray They cannot have a coffee because there's enough
That's the
milk.
problem. That's the problem.
But this is the synagogue. You go to church, you go to mosque, everybody have
That's the
this.
problem, counselor. That's the very problem I'm talking about, which is the ability to monitor the situation and ensure that what you're representing to us here in the hearing is exactly what's going to be going on after the grant. And just the fact that your architect is telling me a whole nother story from what you're trying to tell me. You're telling me it'll be a small event after a bar mitzvah, 50 people.
Won't you
want to
come
go
and
for
visit us
coffee?
on Shabbat? I invite
Excuse
you.
me.
I invite you to
Excuse
come on
me.
Shabbat and see.
Excuse me.
Stop interrupting the commissioner.
Yeah, he's muted now.
Thank you.
Go ahead.
When you're telling us it's going to be 40 to 50 people who want a piece of cake and coffee and chat with each other following a bar mitzvah or a bat mitzvah, and now your architect is telling us that no, this is going to be coffee and cake for 200 people, 50 of whom will sit in the cellar, the other 150 will be walking throughout the building, and then probably walking out on the lawn and walking outside, and then it becomes a very intensive use. And it becomes disruptive to the neighbors.
Which is why we merely wanted the opportunity to present evidence to the board of what would be an appropriate refrigerated facility to have for a congregation of this nature.
Okay, so I just want to cut to the chase again, because we've been talking about this for, I don't remember how many hearings. You were instructed at the very first hearing to return the space downstairs to the status quo. That continues to be the instruction. Do that thing. No, you can't have a walk-in refrigerator because of the very things that Commissioner Otley Brown pointed out. Why in the world would anyone need that unless you're going to be storing a lot of stuff that needs to be refrigerated? If we're talking about coffee and cake after an event, I don't know what kind of cake goes into a walk-in refrigerator. Most of the time, it's made outside and it's brought in and it needs to stay out on a countertop. Nothing like nastiness of a cold cake, right? Unless it's ice cream cake.
Which was the reason I just asked for a potential reduction in the refrigerated facility so that
But the thing is, unless it's reduced to the size of a regular refrigerator,
okay.
that I don't understand even how you do that, but I would suggest that your walk-in refrigerator has value. It should be sold in the marketplace with value. And with that money, you go and you buy a refrigerator that's appropriate to use, that you see in small synagogues that hold events following a bris or a small bar mitzvah that's not going to follow on to the catering facility, or it is right after that they go to the catering for the party.
Okay.
I don't know how to make this any clearer. And Mr. Lee, I don't know how to make this clearer. All right?
Okay. We get it.
Okay, good. Let's not drag this out for years, please.
Okay. I think that
Okay, I remove the refrigerator. I remove it. What next? I took the whole thing down. What else? Are they going to give us the variance? I'll give them in writing. I'm tired of back and forth. But what else I need to do?
All right, Mr. Lobel will tell you what's going to go on. So, all right, because then he's your.
But regarding one thing, Madam Chair, I need to ask you, because you told us before regarding the plant. None of the neighbors have an issue if we put in plant or not, because it doesn't look anyway. I have to tell you what we did. I know, I hear you. Please just listen to me.
We're not discussing the plants. We already discussed that it's not.
Why you wouldn't expect the thing that I want to do nicely? Why, please?
Mr. Levy, it's not negotiable. We're done with this. Okay?
It's going to damage the building.
I'm not having a discussion anymore and I'm muting you. I'm sorry. Nothing personal. Okay, let's move on.
Chair, we could have used you at the last presidential debate.
It wouldn't have worked. But a mute button.
No, but why are you muting me?
I'm muting you because I don't want you to speak anymore. It's very simple. Mr. Lobel, your attorney.
Mr. Levy, I suggest you cease speaking and follow Mr. Lobel's instructions for your benefit.
I think we've isolated the discussion and the concerns of the board. If there are any other points, we'd be happy to address them. Other than that, we would just seek a submission date.
Okay, so as I mentioned, you can listen to the review session notes. There was this floating floor area calculation sheet that probably was submitted by mistake. I don't know. We wanted to know the status of the Environmental Control Board violations. I'd like to hear from fire department in a second. We're trying to understand what that lease is all about now. It seems to be irrelevant. I don't really understand. Who is BJC Gourmet LLC?
BJC Gourmet is merely the business operating arm of the synagogue. The lease could not be entered into with a nonprofit for reasons of the lessor. And so this is it's basically an LLC which was established in order for the purpose of entering into the commercial lease.
Mhm.
And I can quickly comment on that second floor sketch. There was a question a while back about how the floor area differed on the second floor because the envelope changed since the original grant. And as noted, some of the dimensions changed on the plan. So we were just correcting what was previously submitted. There was a second floor sketch submitted previously. And we're just making sure that all the numbers match up.
Okay, it's just that there's two of those drawings in the set, so one has to go. So I understand. I was looking at the other calculation sheet, and this one looks nothing like it. So
yeah, the separate one, we could probably just remove it entirely. I believe that the new set of plans actually do a much better job illustrating the floor area than what was originally submitted, which is why that second sketch was originally submitted. But we can remove it completely. I don't think it's even necessary anymore.
So in future, please don't submit like one drawing, independent, floating in the ether. Always submit it with a set of plans so we know what it's about, and then always with a letter that explains why you're submitting a document. All right?
Absolutely.
Okay. All right. Let me see.
Members of the public?
Yeah. Okay, go for members of the public.
This application is 2308BZ. Sorry. 8014 Chevy Chase Street, Queens.
If you would like to testify on this application, please dial 646-558-8656 and enter the webinar ID 985-2595-2621. And once you've called in, please indicate that you would like to speak by using Zoom's raise hand feature, or if you're calling by telephone, please press *9. Again, if you're calling by telephone and you would like to speak on this application, please press *9.
Okay, and in the meantime, I just want to direct also your attention to the restrictive declaration that made all these representations about what's going to happen sort of as operational plan. And so that has to be coordinated with, as what we described before, as a believable plan for life events that will be small and will rely when they're larger. And when I say small, I mean small, will rely when they're larger on that lease for the restaurant. And if you could please explain what in the world that lease on the restaurant is for. Describes the work as kosher catering or kosher kitchen somehow. Okay, Mr. Levy, I'm unmuting you, but please try not to interrupt when we ask you or say something. The way people speak is I speak, you speak, like that, okay? One at a time. All right, I'm asking you to unmute, please. Go ahead.
Can I speak?
Yes.
Okay. The BGC, when we took the restaurant, the landlord of that building, and you have his number, I can forward it to you guys. You can speak to him. He said, I'm not going to lease the restaurant for nonprofit organization for financial issues, so they don't have an issue with whatever. So I told them, he told me you cannot put synagogue. I don't want anything to do with the synagogue. If you want to be a personal guarantee, you do it and you open LLC and I'll list you the place. And when we took the place, we told them it's specifically for cook over there for the synagogue. That's what we agreed on the first time when we took that restaurant, so we can cook over there. We don't cook anymore in the synagogue at all for the last few months since we took it. So that's the reason we put the BGC, the Bukharin Jewish Center Gourmet, so we just cook over there. And whatever they have, we have small occasion or whatever. So we take it to the synagogue to eat. And plus, we're using the restaurant also up to 40 people. That's how much people they can feed there for like small bar mitzvah or small breaks. So we're using the restaurant hall over there. That's the reason. Yeah.
Sorry, I didn't understand that last part. You said, what about the 40 people in the restaurant?
We use in the restaurant. We also do brace or bar mitzvah. We don't use now. We use a lot less the synagogue facility in the basement because of the COVID-19, obviously, and everything, you know. And so it is what it is now. So we use mainly the restaurant, but we just opened the restaurant about last week because we couldn't open because of the COVID. We all did with just cooking. That's the main thing. It's a very big. That's why I bring even the neighbors. They see everything. The kitchen is commercial and it's legit. It's legal. Everything is okay there. And the reason PGC that we put is connected to our synagogue. So our trustee know that we purchased it. You see the contract, we pay $149,000 to purchase the lease from the last owner, you know, the last restaurant.
So let me understand this. Does the restaurant operate for anyone else or it's
No.
just
No, it's only ours completely.
sole occupant of this restaurant now?
Yes.
So can anybody walk into the restaurant and?
No, you cannot. It's not open to public. Only when on vacation, ma'am. Only when on occasion we open it. Only when we need to cook over there we open. It's not open to public. We don't have resale tax over there. Nothing. It's completely closed.
Okay, how far away is it from the synagogue?
It's about a block away. I would say it's about 800 feet.
Okay. So to calm everyone down here, have a full cooking ability in this restaurant, which presumably in the future, I'm not saying right now because of course we're so limited on what we can do, but in the future, how many seats are there in this restaurant?
When we bought it, they allowed up to 60 to 75 people max.
So it's a 75 person max.
That's it. Yeah, that I don't remember, but I think 675. Yeah, about 75. Let's make it right.
All right. So explain to me why we couldn't work out something like this, where the only thing that goes on in the synagogue is basically post-family event is coffee and cake, right? Or let's say coffee and cake. That's it.
And fruit, vegetables.
But uncooked vegetables. We're just talking about like little crudités
Right,
and
right.
an apple and an orange in a bowl, right? No cooking, no cooked things other than the coffee. Okay? What if that's the only thing that happens at the synagogue? And for all cooked events, everyone goes to the 800-foot away restaurant.
I don't see a problem. I think we can manageable to do that. It's manageable to do it. We just purchased the restaurant. There isn't, as you know, some people say, oh, we already have the hall, just bring it here. We'll be here in the same spot. If it's rain or it's snow, they don't have to walk, you know what I mean? But now with this situation, if it's going to make it happen, I don't know, everything you asked me to do so far, I was very loyal and I did everything you guys asked me to do. I keep my promises, you know. I do everything right for everyone, and I'll do it. Like I told you, I removed the walk-in refrigerator, no problem. I put regular refrigerator because I'm in the restaurant. Really, in the basement, it's a huge walking. I don't need two. You're right. Just sometimes, you know, you're dealing with public. You're dealing with the congregants. You know how is it? I don't have to tell you. Everybody gave it 100 opinion. You know, I'm the wandering Jew. I'm getting all the bidding from everybody. You know, I'm trying to do the right thing for everyone. Just I have any mercy. I'll do what he asked me to do, but I really want to over with everything.
Right. Okay.
I'll give you in writing everything, and if anything I did wrong, you personally me, I mean, fine me, put me in prison, whatever you want to do.
We don't want to fine you. We don't actually want to see this again. But the point is that when the neighbors complain that there are big parties going on inside, here we are again. And I know
we stopped it. And we stopped it. We stopped it. I promise you, we did stop it.
Well, let's just say, look at how many, I don't know how many times we've been in hearing, but this has been here for a long time because of the bad behavior, right? So let's try to set up something that we can believe, especially Commissioner Otley Brown, who you can see has this I'm not sure look on her face very, very much big time. So you need to make something believable. And the fact that the restaurant is only 800 feet away makes it harder to understand why, you know, the only thing you need is a place to put a few bottles of milk or whatever, and for the coffee. That's it. Right? Because
I hear what you're saying. I understand what you're saying exactly. I'm gonna put forward this. I'm gonna fix it. I'm gonna change again the system that we did over there. Again, I need a little bit time to run this over to them and they accept this. Hopefully, you know what I mean. It's not a one-man show. You know, we have a trustee, we have a board. I have to go through everything. You know. But if I say something, they're usually 99% all behind me.
Good.
And one more thing, I tell you, Miss Madam, you know, I really like you guys to come one Shabbat to a service and see how we are with everybody. You can just surprise us even and see how we run everything clean and everything. Really, it's not regular synagogue that we're making chaos. We're not. We're very unique people who try to obey the law. We did a mistake. Personally, we did a lot of mistakes. We break the laws, everything. We realize that. That's why we fixed everything. That's why we're putting all this money back to fix everything. We learn from where we walk, you know. We didn't know about all these laws and everything. We really don't. We just came to this country 20, 25 years ago. So I'm not, you know what I mean?
Yes. Okay. Thank you very much, Mr. Levy. We're going to move on. I appreciate your testimony. Mr. LaBelle, anything left?
No, I think we've summed it up. We're just going to need a little bit of time.
Yeah. So the biggest thing you need is to cure your issue with the overbuild on city property and to get us a survey. Those are the biggest issues. But
Yes.
have time to bring in the contractor or the whatever it is to dismantle the refrigerator and list it on eBay or wherever it is you go to sell the refrigerator.
If you have anybody, I can donate it. You have anybody, any organization? I'll donate first.
Lots of organizations that could use it. So
Which?
I'm sure there are a lot of organizations like.
Oh, if you know anybody, I will do it. I'll personally will send it.
Great.
No problem.
Thank you.
Okay.
All right. Thank you very much, everyone. We're going to move on.
Thank you, Chair.
Thank you.
Thank you.
New case, item number 18, 80361BZ, 1416 Highland Boulevard, Staten Island.
Hi.
Hi.
Lise Fullader from Eric Palatnik PC. We should also have Mr. Andrew Stewart on the call. He is from High Point Engineering.
He is not called in yet.
Okay, I will email him right now. Or actually, maybe I should call him.
Yeah. And I took Mr. Escobar out of the kind of hearing room because he was with the last case and I think he probably wasn't listening.
Okay.
Okay.
I just emailed him.
Okay, do you want to start with Ms. Folder?
Okay, I'll start.
Raise your right hand. Do you affirm to tell the truth, the whole truth, and nothing but the truth with your testimony before this board and to respond honestly to board member questions?
I do. Thank you very much.
Please proceed.
So firstly, I wanted to say that I realized those photographs, this was filed a while ago, and those photographs were old with construction. We can get new photographs for the next hearing. That's not a problem. Next, I wanted to talk about the what you called a convenience store. If you look at Z006 of the current plans, and you look at BSA 004 of the previously approved plans, while the interior layouts are slightly different, it was approved for a 325 square foot accessory sales area, and currently we are asking for a 326.9 square foot of accessory sales area. It's an accessory sales area, does not rise to the level of a big convenience store, and it is about the same square footage. It's like 1 square foot off.
Wait, okay. Sorry, the previously.
So previously approved, go to BSA 004, the last page.
Okay.
And it says the total, it has a TTPN, 325 square feet.
So the conclusion was yes, you can do it?
Well,
No.
it does
Okay,
meet the
good.
TPPN, but I'm just
That
showing
makes me
that
feel better.
that while maybe the interior layout has changed slightly, what we're asking for
will.
is the same uses, and it's a use variance.
Thank you so much for what you're doing. Thank you.
Oh, Commissioner Sheta, I think you have to mute. Yeah, thanks.
Sorry.
Okay, so, all right, so I see on BSA 004, sales area per TPPN 10 of 99. So you're saying you already had your convenience store under 10 of 99?
Yeah, and this was, sometimes we build much bigger convenience stores, but this is not that situation. This is a minor sales area that's accessory to the lubricatorium / service bays.
Okay. So now I just want to go to the proposed.
And it's the same existing building. We don't want any changes. We're not asking for any changes to the building.
So, okay, so then the only, all right, so if you could clarify that in your.
I can, yeah.
So the only issue, like sort of change, is this concept of the enclosure around the tire rack then.
And we haven't built that yet. We're asking permission. So the tire rack is really important to this operator who really wants it. And we had a whole conversation about how your board has stated you can't just have things everywhere on the site. They have to be enclosed. They have to look nice. We've enclosed other types of things before. So we told them they have to propose some sort of enclosure, because we've talked about similar like trash enclosures before. So this was a proposition to see if your board would be amenable to putting in that enclosure so that they could have this storage on site.
Mm-hmm. Okay. Okay, you want to continue? I'm trying to.
Yeah, landscaping, we will have to talk with the operator and British Petroleum. So we'll have a conversation with them about adding additional landscaping.
Okay.
And then the last thing is I maybe want to call Andy because I wanted him to speak on the lighting. We've been talking to British Petroleum about your new administrative notice, and we're having lots of conversations with them about that. This was filed prior to that because that's pretty new. And I wanted him to explain how the lighting was calculated. So maybe I'll give him a call.
Okay. You're trying to call him?
Yeah, is that okay?
Yeah, sure.
Oh, he's muting. I had to call in. I couldn't get on via Zoom directly. I'm muted.
Muted? Where is he muted?
His number is a 516 number, probably.
Oh, yeah, there we go. Allow to talk. Yes. Now he's unmuted. And he has to unmute himself by dialing. There we go. He's got it.
I'm here.
There you go. State your name.
This is Andy Stewart from High Point Engineering.
All right, let me swear you in, Mr. Stewart. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Proceed, Mr. Stewart.
So it's my understanding, Elise wanted me to speak to you about the lighting plan. I was in review of the review session, so I did hear the comments. The lighting plan, as Elise said at the time, this was prepared. The new directive regarding actual field measurements for lighting had not come out. And so we have discussed with the board previously on other applications, this lighting has been done with a photometric lighting program. Where the existing lights and any applicable shielding, as shown, the proposed shields on the area lights, any opaque slats, opaque fences, as they are at the property line. There's a 6-foot high chain link fence with slats. They're all taken into account, inputted into the lighting program, and then it spits out the photometric grid as shown on the plan. The reasoning for, and I'm looking now specifically in the, I guess it's the southwest corner, where's the area light towards Highland Boulevard. The high readings there with the 0 on the opposite side of the fence on the adjacent property line. The high levels are from not just the area light, but also the nearby canopy down lights attributed to those numbers as well. Between the shield on the area light and the fence, and also the fact that the photometric program, these numbers, when they're generated at an equivalent of about 2 to 2.5 feet above ground. That's the reason why it's shown such a drastic change from the numbers on site to the 0 just on the other side of the fence. If you were to take a light meter and put it about 2 to 2.5 feet off the ground right next to the fence as where the points are shown here, between the shields from the light and whatever and the fence, the opaque slats in the fence, that's the reason why it's coming out and showing as 0 from the program output.
Can you model this also higher? Because what we're trying to do is get to right above the fence.
I understand. I can take a look into see if we can put a higher modeling on it. I think it's typically done, like I said, at 2 and 2.5 feet. It may be set at that level. I have to check. I don't run the programs myself. It is run through a CAD lighting type software. So I'll check into that and see if we can do that.
And again, what kind of boundary condition you mentioned that caused that 0 value at the property line? My understanding is you have 2 sources of light. If you look at the southwestern corner, yes, where the value says 26.6 and 25.5, my understanding is that you have 2 light sources shedding light to the spot at 26.6, for example. One of them is the light pole to the left or at the bottom, and the other one is the canopy lights, like you said. So if you have 2 sources and they are shedding light perpendicular in 2 perpendicular directions, why would the value to the right of the 26.6 be 0 like that?
So, like I said, so all these points you're seeing on the grid right now, they're an estimated value at about 2.5 feet above ground, based on the lighting, the files that are provided for the types of light. They're a file that basically simulates what the lumen output of these lights would be. If you were to go on the other side of the fence, which is a chain link with opaque slats, so it's an opaque fence, at about 2.5 feet, and show maybe a foot off the fence there, based on the fact with the fence plus the shield that's proposed on the back of the area light, that's taken into account in the program as well.
Okay.
Those items serve to shield out the light at that lower level right next to the fence, which is why it comes up as 0.
So apparently you're considering the fence as if it was like a really light preventing boundary condition. So meaning that this is kind of like, it's not glass, it cannot allow the light to cross. It's something like solid.
That's
right?
Correct. It's based on the opaque slats that are within the fence. The program interprets as a solid, like a solid wall, basically. So it blocks the light.
This is not the case in most of the fences. If it's even if it's a slated fence, it's gonna have some sort of like partial permeation for the light. It's part of the light's gonna penetrate to the other side, right?
Yeah, I understand what you're saying. It's just this is how the program works. I can look into it to see if there's any way of assuming a level of transparency to the fence, but I don't think that's how it works. I'd have to look into it, to be honest with you.
Can you please, next time you submit, can you give us some information about that software, like what kind of it, what is the basis, and the name of the software, so we can probably download a trial version and look at it?
Yes, I can provide that information.
Thank you.
Okay. Yeah, so with this, the cut sheets that we talked about would be really helpful. Both the cut sheet with the lumen spread for the lamp itself, and also with the lumen spread for the shield. Like, what shield are you proposing to use that works so efficiently? And don't forget, what we're really talking about is the lighting and its effect on a house that is, I believe it's two or 3 stories tall, right? So lighting that's shining right into the window of somebody who lives right next door.
And in addition to what I said, if you can, you're the expert here, if you can please explore the program capabilities, see if it can give lumen values at different elevations from grade. My understanding is these are like 30 inches above grade. If there is a software like this, and I haven't even used any software like that in my life. I'm not a site civil engineer. I do structural and geotech, but my understanding that if this is a numerical analysis based software, you should be able to change the elevation for the cut section where you get these lumen values at. So it could be 30 inches, it could be 2 feet, could be 10 feet. So if this is possible, probably it could be beneficial to look at the elevation above the fence and even going up. If we have an adjacent window, we want to make sure that the lumen spread at that window is not significantly impacted.
Understood. 2 points to that. I can look into it. I can't guarantee that the software can interpret it at a higher position at the fence line, top of the fence line. My initial thought is that it may not be able to, because I know we've gone through this discussion on other sites with this software before, but I will confirm that. The second item is that the adjacent mixed commercial residential building with the residences at the second and or third floors elevated, these lights, the canopy down lights as well as the area lights, are shining downwards toward the ground. They're not shining up. That would impact a second or even third story residence like it would if it was something at the ground level.
What's the height of these fixtures?
The area lights are probably about 14 feet, and the maybe 12. I'll have to confirm that. That's a typical height for area lights at a gas station. The canopy down lights are directly downward. They're at the underside of the canopy, which is about 15 feet.
Okay. So
That's
again,
Z004, sorry.
give us the light spread diagrams so that we can really understand that, because 14 feet is still 7 feet above or 8 feet above the fence, right? So that shield has to be making sure that it wraps adequately around the back of the light to not be shielding onto the property. You know,
Understood.
hiding a foot away from a fence 2 feet above, yeah, it's dark down there, but then you stand up, right? So, okay, thank you. I'm sorry. Ms. Fullader, did you want to add something?
Oh, I was just saying, if you were asking about lighting and heights, it was on Z004. I was just trying to help.
Oh, C004. Oh, thanks. Pole sign. That's for the canopy.
Yeah.
But I don't see, the canopy is almost 15 feet to the bottom, but it doesn't show the pole lights.
We can confirm the height of the poles and add in the heights on the notes, whether it's called as an existing single fixture area light with proposed shield. We can add the heights to those labels.
All right. Good. So then you want to continue, Ms. Fullader, or you?
I'm not sure there was any other comments.
Yeah, so for me, it was the location. Well, no, actually, Commissioner Sheta and I were both talking at length about the tires, that they not be stored. Well, for one, he was talking about an enclosure of PVC not being appropriate. And I was looking at it and it's like, why are you putting it in the area opposite the residences?
Well, I was saying that it was proposed and we proposed it to the best of our ability. We made sure that it was in an enclosure similar to a trash enclosure. We've discussed on other gas station applications that you don't want anything on the outside, you want everything enclosed. So this this enclosure was really important. Tires are really important to the operator. And that was just a suggestion proposed to the board.
Right, but why not put it on away from the residence? You're backing up against two houses with all of that. This is the classic thing where the houses suffer.
Andy, can we look into putting it somewhere else?
We can look at putting it somewhere else, but I think the reasoning we were putting it behind the building, it's a more convenient space. It's not in the way of traffic. There are the striped stalls to the south of the building there, those 5 stalls, which are used just for cars awaiting service. They're not any actual customers pulling themselves in or out of the stalls. Those are controlled by the service bay operators themselves. So that this was the safest and most appropriate place that we saw to put this enclosure. We are proposing it at a height of about 13 feet, which would fully screen the racks from any view from the adjacent properties, and we want to put in, like you said, a white PVC enclosure, not just something chain link, something that's more aesthetically pleasing than like a chain link fence or anything like that.
So this is my mantra. You live in the house that's called reputed owner Edward Russo. That's your house. What do you want behind your house?
Understood. At the same time, I'm not, and then I don't know what came first, the house or the gas station, but they did buy a house next to the gas station.
We're looking to put a situation that works for everyone, a nice fence that he's not going to look out and see something terrible.
Let's start again. You missed my point. You, sir, own Mr. Russo's house now. You bought it. And when you bought it, the only thing there was what there is now, which is the existing 1-story building. And you find out, unfortunately, while it's under construction, that they're going to be adding a dumpster, tire racks, PVC fencing that goes to I don't know whatever level, and now you're stuck looking at it. And by the way, your house, I believe, is a 2-story house, so your kids get a view of all that stuff from their window. So my answer again is, what would you do? What would you want for your house? Not, did you come to the nuisance who was there first? That's not my question. So the answer is, all of that stuff that's put there for the convenience of the commercial establishment has to take into the account the fact that it's up against the boundary of residences. And so that's not a good site for it. Okay.
I understand, and I definitely understand where you're coming from, and I completely separate from the application. I may agree with you, I may not, but I, of course, again, as you know, I have to. My client is the gas station, is BP. Question for you: instead of a PVC fence, if we were to put up a fence, say a chain link, but with that kind of faux green type of landscaping inserts, would that be more appeasable?
Worse. Chain link fences with that stuff falls out. It's terrible.
I'm just putting out an option.
Okay, but let me just go back. If your client needs to be present at these hearings to hear the instruction, please have your client come, because this is a variance, right? A variance is a special permission to operate a use that wouldn't normally be permitted in the district. You can't get, let's say your client can't have it all. They have to give back.
Yeah, we understand that our client have it all, and that's why this is proposed. We're looking for something that works for everyone, and that's what we're trying to achieve here. We're asking your permission to find something that works for everyone, and that's all we're trying to do.
So my suggestion is to move it to the side that's more commercial.
Okay, we can definitely discuss that with the client and see.
And that's why it's not put in. We're just proposing ideas.
Okay, good. That's good. I'm glad it's not put in, so at least we can have this discussion and we don't cost your client money and have him take it out.
But also just, having a business businesses are struggling right now. And I know you've heard that a million times, but just being able to have a business there, but also appease all the neighbors around and be good, a good service operator is also important to us. We want to do everything and we want to work on that together.
Right.
Thank you. Is this proposed to be a roofed structure or without roof, open to sky?
I think right now it's open to sky, but I think yes, sorry.
Yeah, I was going to say it would be open, as if you look at sheet Z005 with the elevation of the back of the building. While the racks and everything are enclosed, there are some existing tank vent risers in the back that come up through the top of come up the side of the building that go up above the building as per requirements. But it would be an open top.
Right, it has to remain open, otherwise it would be counted in the floor area, and you would need to provide additional fire safety measures, maybe fire suppression units and such, if it were enclosed. And we have to make that very clear in the plan that this is not an enclosed structure.
Correct.
It has to remain open to sky.
Yep.
Right, except that maybe having it an enclosed structure with fire suppression is the right way to go, for example. For instance, we have one case not too long ago where the tires were kept inside the repair facility on beautifully installed wall-mounted racks.
Yeah.
And it seemed to work out great. And rather than imposing the tires on the community, rather than, I'm being advised that this is still an amendment, and Carlo, please speak up because I'm not sure I'm getting this. It seems as if the convenience store already existed. So the only thing that's being asked to do now is for this tire storage area. I don't know if that constitutes an amendment without a little help from those specialists who always work on these applications.
Because we do trash enclosures all the time, and that doesn't usually rise to the level of an amendment. That's why we didn't.
Well, that's because you always have trash, right? And the trash is. This is different. You're asking to store the tires outside, which was never the case. So I'm not actually sure that it's not an amendment, but I'm being advised that if it is an amendment, you need to file it.
Yes, Madam Chair, no, for Elise, I'm sorry, I thought, I didn't hear the part about the convenience store having been in existence, so I thought that was the amendment. As far as this enclosure goes, I'm not sure. I wasn't thinking about that.
Right.
I was still coupling it in with the potential of legalization of a convenience store.
Right. Okay. So I would like to suggest, first of all, because we had such a good solution with this other applicant of having the tires stored inside rather than outside, that be looked at, because I'm looking at the service bays and I looked at, it was a much smaller operation in that other site, and they mounted the tire racks to the wall and they stored a lot of tires, right? So maybe it can work being inside. The other question is, maybe the enlargement of the building is the right way to go. If it's possible, I don't know. And then the other thing is to move it to another side where you're not imposing all the nastiness on the residents, because it's sort of like in the backyard, out of my sight, out of my mind, and therefore in the yard of Mr. Russo or his beneficiaries.
I believe this is going to be a precedent if we allow storage in an enclosure like that for something other than trash. Any business that's willing to secure some additional floor area without needing to actually apply for getting floor area, like enlarging the building, would come and seek a solution like that. And honestly, if I own one of the houses next door, I wouldn't be happy opening my window on the second floor and looking down and seeing an enclosure open to sky with tires inside. So I would suggest that the direction to be either go with an enlargement for the building or put the tires inside in racks inside the building, which is gonna give peace of mind to the adjacent residences.
And I'd like to, yeah, sorry, go ahead.
I was just going to say that we'll have to obviously discuss with our client, and we'll have to get back to you on how they want to proceed. So.
And I understand your point about precedents, and I just want to say that we've had solutions like this before. That's why we came up with this solution for other automotive service stations. Right. And I know it's the past, but.
Right, it's the past, and as we keep talking about as we move forward on these applications, The theme of the year, in addition to all these terrible themes of the year, is environmental justice, right? And we've been pursuing that for a long time here, but we're fine tuning it as we go. The more we learn, the more we say, it's not okay to impose this on the neighbors. Just because way back in the past, there was a variance granted for a use that's really not desirable. And I'm not sure how many people standing in this room or sitting in the room would voluntarily buy a house that backs up against an automotive service station, but certainly wouldn't want to continue to own a house where, or might have trouble selling a house where the service station becomes more and more imposing. So, the opposite should be the case, that the station softens its presence. That's why we're talking about landscaping at the back. And while we're at it, the landscaping should be significant, because we're trying to buffer this use from the adjacent owners, right? And we haven't gotten into the details, but when we talk about a buffer zone, we talk about something significant, like an 8-foot wide buffer zone, and you've got 14 feet there. So in the end, there wouldn't be room for your tire storage. Right? And when we talk about a buffer zone, we're talking about staggered, the equivalent of arbor vitae that grow to create a dense visual buffer, buffers the fumes and buffers the visuals. And so in the end, no room for tire storage, so gotta find another place. Okay?
We will have a discussion with the client about all their options, and we'll come back to you with a solution.
Okay. All right.
Okay, you're gonna open this up for the public? Okay, this is 803 61BZ, 1416 Highland Boulevard, Staten Island. You wish to call in, it's Zoom web ID number is 985-2595-2621. Telephone number is 646-558-8656.
And if you have already called in, please use Zoom's raise hand feature to let us know that you would like to present testimony.
Sorry, yes.
Okay, so in the meantime, how much do you need to?
I guess we need a little bit of time, because we have to present the different ideas to the client and the operator, which is different levels, and see what solution they might want to do for the tires.
Okay, and all right, so Mr. Stewart, you're the one who does the drawings, right?
Correct.
So give me an idea so we can tentatively figure out your schedule.
I mean, on our end, drawings would not take very long to revise. It's more of kind of discussing with the client and trying to get a game plan together that on the what we're showing here that would appease everybody, that would be satisfactory to everybody. So, at least what would you say? Maybe 2 months, maybe.
Yeah, something like that. It's like the biggest issue is just going to be getting to all the levels and making sure whatever the solution is that whatever they want to do, because I know that we discussed a lot before we came here how important that tire storage was for the operator to run his business.
Right. So what I'd recommend is, so that your client understands how much we believe in our position, you have them listen to this hearing.
I always send the hearing. I will continue to do that.
I appreciate that. Okay. All right. So I'm marking 8 weeks to submit, and let us know if it turns out you need more time before the calendar is issued next week. Okay.
Thank you very much.
Okay. Thank you.
Item number, 19-141-66BZ, 338 East 9th Street, Manhattan. This is the law office of Frederick Becker. Mr. Becker, you're muted.
You're muted. We cannot hear a word. Unmute yourself.
How about now?
Yeah, okay, good. Okay, raise your right hand. Let me swear you in. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do.
Please state your name and proceed.
Frederick A. Becker, a good afternoon, Madam Chair, Commissioners. We listened to your review session, As you said, we received basically a waiver from the community board. They've had no objections and support the application. With regard to comments that have been made, the issue of the sales was something that was a carryover from previous resolutions, but we are happy to remove that from the plans, Madam Chair. So we'll take off the word sales from the plans.
So there are no sales?
Yes?
Are
No, there
there?
are no sales.
There are no sales. Okay.
No, no sales. So we'll just take that word off the plans.
Okay.
Okay. With regard to the door that Commissioner Otley Brown mentioned, this has been in existence. It has shown up on various plans. It's a convenience store to the next door property. We would like, it's a fireproof self-closing door. We'll put it back on the plans. With regard to the fire safety, we've had prior CFOs issued with the current conditions. We have smoke alarms, fire extinguishers, and exit signs.
Okay.
And I think those were the only comments that were made.
That's correct. All
And
right.
we
Go ahead.
can make the changes in 24, 48 hours.
Okay. All right. I'm making a note. Chief Daly, did you want to speak to this? There's a little bit of.
Oh, yes, and in response to Commissioner Shedder's question, the site has been in existence for many years, has been inspected by the fire department. Any additional fire protection system required is not applicable for the site, and it has had a certificate of occupancy for many years. So for my recommendation of putting in the sprinkler system is not valid. It is a small site, and the department, like I said, has inspected, and we have no objection to this application.
Okay. Great.
Perfect. Thank you.
You're welcome, sir.
All right, then. Let's go to the public.
This is 14166 BZ, 338 East 9th Street, Manhattan. If you wish to call in, 646-558-8656. The ID number is 985-2595-2621. And if you're calling in on Zoom, I don't know, Kurt, I never remember that, sorry.
If you're calling in on Zoom, please use the raise hand feature to let us know that
Raise
you'd
hand
like to
feature.
testify.
Thank you, sorry.
Time delay. No one has their hands up who are in the attendees list. Okay. All right then, Mr. Becker, thank you very much. And we'll
Want to close?
Oh yeah, we could close with this, right? There's nothing that's substantive. Okay, yeah, let's close. Good idea. So a motion to close?
Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
So time frame for the plan?
He said 1 week, right? So
Yeah,
I'll try to put this on for decision at the next hearing or the one right after that, okay?
Great. Thank you very much.
Thank you.
Thank you.
Well, bye-bye.
Next item is item number 231377 BZ, 1200 Broadway and 17-27 West 29th Street. Oh,
Sorry to interrupt. Could we take a like
Oh,
3
yeah.
to 5 minute break?
I'm so sorry. Thank you for pointing it out. Yeah, we've been.
oh yeah,
going-
it's 4:30. Sorry. Ooh, sorry, yeah.
Thank you, Commissioner Ollie Brown. I was like in a zone. Yeah, 10-minute break. So coming back at 4:35. Okay, is that good? Thank you. Thank you for pointing it out, Missed.
Hello, hello.
Okay. Who are we missing? Vice Chair Shanda? There you go. I think we have everyone. Okay. So Tony, when you're ready, can you read the case number, please?
Are we live? Okay.
Live, yes.
Okay. The case that we're discussing is 331-77BZ, 1200 Broadway and 17-27 West 29th Street.
Sorry, it's 31377BZ.
Oh, I'm sorry, 313. I wrote that down wrong. I apologize.
Okay. Go ahead. So we see Mr. Selver, Ms.
Campbell.
So
Who else?
please identify yourself and tell us who's in your team.
Okay, well, you see Valerie Campbell and
Turn off your YouTube.
Yeah, everyone must turn off their YouTubes and turn off, yeah, everything except their Zoom video. And if you're calling in, then you should not have anything computer-wise on. Okay, somebody has a lot of feedback, so please mute yourself until you're called. Okay. Okay, so Mr. Selver, proceed.
We'd have to swear them in.
No, I just want him to tell us who's in his team.
Oh, I'm sorry.
so Paul,
His audio, Paul's audio, he's either frozen or his audio is very poor.
okay. Okay, I think I should.
Someone is listening to this on YouTube and they have to turn off their YouTube. Because I can hear myself repeating myself.
Are we good? Yeah,
No,
I think
we still hear YouTube.
Still hearing someone on YouTube. Please, whoever is listening to us on YouTube, mute yourself. I'm going to mute everyone.
wait a second, let me just check something. I don't believe it's me, but you know, I don't think it's me. No, wait a sec.
I think it's you. You're
I
the
just
only
wanted,
one muted.
I just want to be sure that I'm not on YouTube.
You could be, I think you're on YouTube on another tab on your screen.
Yeah, hang on. I should be out of it now. Yeah, okay, I'm sorry.
Better. Okay, that's
I
good.
thought I turned it off. So, all right, thank you very much, Paul Selver, Creamer 11, for Gilsey House. And our group today includes Valerie Campbell, my partner. I think Sam Brill is also part of our group, who is my colleague, and he is running the slides. Sani Mackey is also here. Sani is the former president of the board of Gilsey House, I believe. I may have his exact title incorrect, but seems
You're
to be
correct.
in his head. I don't think we have anyone else here as part of our panel.
Okay, John Shannon, Anna Mackey, Jason Crane, any of those people in your team?
John Shannon is part of our team. He represents the developer. Anna Mackey, I assume, is related to Sani.
She's a resident of Gilsey, as well as Jason Crane, and potentially other residents that I might have dialed in.
Okay.
Okay. All right, go ahead. So
So I think I need sworn in.
Yeah.
Are we ready?
Go ahead.
Okay. Please raise your right hands. Do you affirm to tell the truth, the whole truth, and nothing but the truth in your testimony before this board, and to respond honestly to board member questions?
I do. Yes.
I didn't hear anybody else, but I'm
I
assuming.
do.
Okay.
I do.
Okay, so I had a very long, again, Paul Silver of Kramer Levin for Gilsey House. I had a very long statement about why we qualified, why we were satisfied the requirements for an amendment under Bella Vista, but I think based on the comments at review session that I don't need to spend a lot of time on that. In fact, I don't need to spend any time on that unless somebody has questions. There were a lot of questions at review session about the details of the Gilsey House changes and the materials that were filed. And I'm going to try to answer them now. I may not be able to answer all of them. I may call on one of my colleagues for help. But I'll start with the discrepancy in the material that the chair referred to in her statement. She noted that material that you'd received at the end of the week on October 1st, it had different figures, different numbers for the existing floor area in Gilsey House and the amount of floor area being transferred. And I ought to say that the material that you received October 1st was not intended to be part of the application. It's actually the presentation materials that we were going to use today. We don't know exactly why the error exists. It should not be part of the record, and we're happy to the extent that it somehow got in there to remove it. But all of the other material in the application is consistent on the existing floor area of Gilsey House, which is 107,000 square feet and change, and the amount of floor area that Gilsey House proposes to convey. Sorry, I'm looking for my notes. Which is 30,700 square feet and change. 30,507 square feet, I'm sorry.
So it's the change that usually messes us up, because when our council writes the resolution, it's kind of 30,000 and which change, I have to actually write something in the resolution. So that's why we need to be sure we know what the numbers are.
Okay, well, we will clarify that, and to the extent that they're eliminate any confusion. But it is those two numbers. So that's number one. Number two, a license, the plot dimensions and size were determined by a licensed survey. It was a survey that was conducted for the purposes of determining how many development rights Gilsey House had available to sell. We have not filed it with we didn't file it with the board, but we're happy to file it with the board as a supplemental piece of our application. Mm-hmm. That survey did not include any of the mezzanines in its treatment of floor area. And it did not include any of the penthouses or I don't know, any of the bulkheads, which some of which may or may not be floor area. What happened then is that we asked Atchison Doyle, who really specialize in, they don't specialize, it's one of the things they specialize in is doing these kind of very detailed surveys of the interior of buildings to establish definitively how much floor area was there. And they went through and measured the inside, including all of the bulkheads, all of the penthouses, and all of the mezzanines. And it is, they used as the baseline, the outlines of the building, if you will, the survey that was prepared by the surveyor. And that is where our numbers come from. The comparison, I think it was Commissioner Sheta asked whether we had a comparison of the zoning floor area in 1977 and 2020. And we think that was filed on sheet SK1 with the board. And if it wasn't, we're happy to fill in whatever information is missing. On the third floor mezzanines, I am told there's a headroom issue, but I've also been told that they're very small. In effect, they're almost like little storage ledges. But whatever the truth is, we will find it out and we will send it. We will write it. We will send you a letter confirming the condition. I'm also going to. I think you're right, Madam Chair, about the definition of floor area. There are such things as mezzanines under Article 5, under Article 1, Chapter 5. If you'll hold on one sec, which I don't think I have deleted from my, from my screen. It is 15-111. The exemption is not strictly from floor area for the building. They're exempted from calculating the minimum required size of dwelling units. Or let me see, not included for computing not included as floor area for the purposes of calculating the minimum required size of a dwelling unit or for calculating floor area devoted to dwelling units. I think at least at one time, the buildings department viewed that as exempting them from floor area, period. But whatever the situation is, we will address it front on in a follow-up letter.
Right. I think that's in days of yore, right? I think that's like in the 1970s.
No, that's in the current, as online zoning resolution.
No, what I mean to say is whether it's floor area.
Oh, that.
Remember in the 70s, early 80s, that was like a commonly held pursuit of architects to create all these funny little mezzanines that were less than X height and therefore wasn't floor area, but the buildings department no longer subscribes to that.
Okay, well, if that's the case, we will address. We'll discuss the facts and we'll discuss, and if it under the facts it is appropriate to add them as floor area, we'll deal with that. The statement that we are adding 2 floors in, I'm not sure where that actually came from because I checked during the break with my colleagues. They said it's not in the application, although it was in my notes from a statement I made to the community board. It's correct in terms of height. That is, we are adding 2.5 floors worth of floor area, but because the additional half floor doesn't increase the height of the building.
Oh.
We're only adding 2 floors in height. I hadn't really thought of it that way, but I am told this is why it was said. Those are the questions that the board asked that I was able to capture in my notes. If there are other questions, I'm happy to take them and try to answer them now, or to let you know that we'll respond in a follow-up writing.
Okay.
We'll also, by the way, review the YouTube
I'm just
video to be sure that we've captured everything.
Right. Okay. So sort of to cut to the chase, we need that survey so we can put together the Atchison-Doyle analysis with the official survey and get the answer, right?
That'll give you the floor areas, yes.
Okay. Okay. I don't think we had any other questions. Okay, so I believe though there are any other questions from commissioners? I need to display. No questions from commissioners. Okay, so then I think there are members of the public who would like to speak. So if you are,
I'm happy to stop sharing my screen. Oh, there we go.
okay. Oh, right, you were sharing the screen and then we decided not to look at it. So,
Well, we decided you had better things to do than listen to me talk for 20 minutes about something you already knew.
thank you. All right. So I'm trying to see the attendees. There's only one person, Jennifer Chang. Is that person registered to speak on this, Kurt?
I did not see her name on the registration list, but she may be one of the people who called in.
Okay, so
Right.
let's.
Jennifer is a resident also of Gilsey. She might not speak. She's already submitted a statement, I believe, in the package as well.
We always
Sure,
allow
sure.
anybody who wants to speak.
Absolutely, absolutely, yes.
So Ms. Chang, if you can hear us, unmute yourself if you want to speak.
Hi. No, I already submitted the statement, so I'm just listening. It's fine. Thank you.
Great, thank you. There are other people who were in our, no, I can't find our room here. There were other people who were in the room who may want to speak. If you do, please put up your Zoom hand. I don't think I see anybody.
Promoted to panelists too, so if they just unmute and state their name, they can start talking.
Okay, it doesn't look like anybody is interested in speaking. I thought we would have members of.
Well, so maybe I should raise my hand because I'm speaking on behalf of the residents and the shareholders. If you'd let me make that statement, then I will do that.
Go ahead.
Okay, and I'm a resident and a board member, but I'm making the statement on behalf of the president of the Gilsey House Co-op. So,
Can you state your name, please?
my name is Sani Mackey.
Go ahead.
Again, good afternoon, Chairperson and members of the board. And thank you again. Thank you for the opportunity to be heard on this application, which is critical to me and to all the residents that I represent at Gilsey House. I want to thank each of the organizations that are supporting our application today, including Council Member Keith Powers, the Manhattan Chamber of Commerce, the New York Building Congress, our neighbors at Marble Collegiate Church, and the overwhelming number of my fellow residents at Gilsey House. They've all submitted testimony in support of the application before you. Our building became a residential co-op in 1977. Shortly thereafter, in 1979, it received designation as a New York City landmark. We are proud of our landmark home and are adamant about remaining the good stewards that we have always been, and we recognize the critical responsibility the city places on us. There are several residents living in our building today that remain from 1979 and who are living on fixed income. The Gilsey House is urgently in need of local law 11 repairs, which our architects estimates will cost us more than $4.5 million. Therefore, we are formally requesting this board approve the application in front of you. Your approval will allow our air rights to be transferred to the only building that can accept these rights, and thereby provide us with the critical resources needed to ensure that the facade is restored to the level both representative and respectful to the building status. The transferred air rights will represent a 2-story increase to a 41-story office building, which is currently under construction at 7 West 29th Street. This is a one-time opportunity that will not come again, and the site is the only one capable of receiving these air rights. The office building at 7 West 29th Street is as of right. It can and will be constructed with or without our development rights. Denial of our application will not stop the office building, but it will hurt the landmark and its residents. For all these reasons that I've mentioned, we believe that the approval of our application is in the broader public interest. I thank you for the opportunity to be heard. And again, on behalf of the residents of our building, we urge you to support this application. Thank you.
Thank you. Any other speakers on this? Jump in if you would like to. So, Mr. Maki, I just want to make sure, and that you were listening to the review session. Because again, and Mr. Silver knows this very well, but this is me, kind of lawyer / architect cautioning clients to not regret in the morning what they did last night, sort of. So the analysis by Atchison Doyle, which is, it measures very close to the bone, and it will mean that there are no future mezzanines that can be added for the convenience of residents who might be envious of the neighbor who has a mezzanine, and that depending on how the Department of Buildings looks at it that week, you might not be able to reclaim mechanical space as floor area in the future. So that's kind of this ever-evolving thing with the Department of Buildings. So kind of what you see is what you've got for all eternity, and you're not allowing any wiggle room. Other than that, I don't know what the 1,000 square foot of saving of reserve is.
Yeah, that was the point of that. All right.
Yeah, so that's very little, as you know. So just to keep in mind, so that everybody goes into this eyes open. Okay, that's just not really BSA admonition. That's a colleague in the land use community who used to advise sellers of development rights like that, which I'm sure you've also heard from your counsel. So.
Yeah. Okay, thank you very much. I appreciate it.
So, all right, then. So do any commissioners have any comments? Otherwise, I would like to close this. Can't see the commissioners. Okay. Commissioners, anything you want to add? Anything? Okay. So, Mr. Silver, how much time to make those really, to give us that information and make the corrections?
I mean, I'm going to say 2 weeks. I'm looking at Val and seeing if she thinks that makes sense.
He's muted, Val.
Val, you're muted.
You're muted. And you're very surreal.
Still muted.
Um,
No, you're not muted anymore.
No, I'm not muted. 2 weeks should be fine.
Okay.
Fine, okay. So I guess the question is, we are checking on the floor area. All we're looking for is the survey to confirm the floor area that you're claiming from the analysis, okay? So that's not a substantive information.
I mean, that's a week, actually.
Yeah, no, but in other words, I'm just looking at whether I can close this. Does anybody have a problem with us closing? Council?
No.
No? Okay, good. So then I would like to make a motion to close, and we'll take note that you can make a submission in 2 weeks, and hopefully I can coordinate this with the calendar, okay?
Okay.
Thank you.
Madam Chair, Commissioners.
Okay, motion to close?
Yes, please.
You ready? Yep. Motion to close, Chair Perlmutter?
Aye.
Vice Chair Chanda?
Aye.
Commissioner Otley Brown?
Aye.
Commissioner Sheta?
Aye.
Commissioner Shabeta?
Aye.
Application is closed,
Thank
waiting
you
for submission.
very much.
Thank you.
Colleen.
Thank you.
Okay, this concludes the public hearing for October 5th, 2020, 2 p.m. session. We will see you tomorrow at 10 a.m.
Bye, everyone. Thank you very much.
Thank you. Bye-bye.
Bye.
Thank you.